So before our lunch break, we talked about all these different ownership interests, ownership estates. We said an estate was just the type of relationship that a person has with a piece of property. And then we talked about the ownership estates and like fee simple absolute ownership or life estate ownership or fee simple defeasible ownership. We are not changing topics. We are building on that topic because up to this point, we've talked about ownership for the most part as a singular experience. In all of the examples we've utilized so far, it's been one owner. You know, Amy owns the property till Amy dies. Molly owns the property and she transfers it to Hilda. It's all been singular. The truth, though, is that very often we have ownership that is shared between people. And so we have to talk about how that sharing works. I think it'll help you just to get in your mindset right here. Are people like naturally very good at sharing, or do you have to like really like lay down the law and set some rules when it comes to sharing anything?
Lay down the law.
I mean, because if you think about just kids, like if you just throw a toy in the middle of the room and say, here, share this, is that a disaster in the making or what?
Bad idea.
Disaster waiting to happen.
Right, a bad idea. And so we have to talk about how the law says these shared ownerships are going to work because they don't always work out. But before we get into the shared ones, let's go ahead and put a name on the one that we've been talking about all along. Up to this point, when we've left everything singular, we were actually talking about something called ownership in severalty. Now that's a kind of a weird vocabulary word because I think people see that and they're like, ownership in severalty, that sounds like there would be several owners. There would be more than one. The truth is ownership in severalty is the same thing as sole ownership, singular ownership. When we say that a person has ownership in severalty, what we are really saying is that this person owns the property by themselves. Does that make sense for everybody when I say it that way? They own the property completely by themselves. They are an owner in severalty. Now, I'll tell you one of the ways that this worked for me, and my brain's a little bit weird, I admit that. One of the ways this worked for me when I was taking the class many years ago, because I was like, this is the dumbest word I've ever seen, ownership in severalty. How am I supposed to remember that's only one? I played this little game with myself, and I actually made this into like a 3-word sentence. If I'm an owner in severalty, I have severed all the ties that I have to anybody else. I have cut all ties with any other owners. I'm the only person who has any ownership. Now, whether that helps you or not, I don't know. You'll just have to sort of, make sure that you find ways, whatever it takes for you to remember that ownership in severalty means ownership by only how many people?
One.
Just one. That's exactly right. Just one. Now, when we talk about ownership by only one person or sole ownership, quite honestly, that makes life easy because we don't have to worry about this whole like, how are we going to share it? Who gets to use the property? How much of it do they get to use? What percentage ownership do they have? It's easy to understand. If there's only one owner, they get to use 100% of the property 100% of the time. They own 100% of it. They can sell it by themselves because they're the only owner. They don't need to talk to anybody else. They don't need to get anybody else's permission. They don't need anybody else to weigh in on the decision making. All of that stuff becomes really straightforward when it's ownership in severalty. It's when you start to share that ownership. It's when you get more than one person involved that things start to get much more complex and confusing. I will tell you that the next little section that we're about to talk about is probably the heaviest tested of all of what we're going to talk about today. So when you're doing your studies, these 3 types of concurrent ownership or shared ownership, really make sure you come back and hammer studying these. I mean, like really, because there are going to be several test questions from these three different types of shared ownership. And the reason there are going to be so many test questions from these three types of shared ownership is that there's arguments among people. People get angry with each other and they start to fight over, well, who owns this and who owns that? And do I have to get my husband's permission to sell? And do I have to get my wife's permission to do this? And well, I own it with my boyfriend, but we're broken up. And what does that mean? And there's all these questions that come into play when you start talking about sharing ownership. That's all called, as a group, concurrent. Concurrent just means more than one owner at the same time. So think of it this way. You've got two types of ownership. Ownership in severalty, which is how many owners?
One.
One.
Oh,
And then you've got concurrent ownership, which is two or more. What we're about to do is break down concurrent ownership into three different pieces. These are the three pieces of concurrent ownership. Concurrent ownership can come in one of three forms. And here's why these questions are really important. We need to answer some things about the sharing of the property. Like, look at these questions. If we've got more than one owner, well, which one of them gets to use the property at any given time? Do you think that's an important question that we need to figure out between if we've got 2 or 3 or 10 different owners? Do we need to figure out who gets to use the property at any given time?
Yes.
Yes.
Yep.
Yeah.
We've got to figure out if every owner has the same percentage share of ownership. Well, I mean, are they equally split? If there's 2 of them, are they 50-50 or are they 60-40 or are they 90-10? And if there's 3 of them, do they each own a third, or does one own 50% and each one of the other 2 own 25%? We got to figure that out when we start talking about sharing ownership. And here's why that's important. If we have 3 owners, I'm just going to throw some percentages up here. Let's say we got owner number 1 who owns 50%. Owner number 2 owns 25%. And owner number 3 owns 25%. If we rent that property out for $10,000 a month, do you think owner number 1 wants to split the rent equally, or does owner number 1 think they're entitled to more money because they have a larger share of ownership in the property?
They're entitled to more.
Larger share of money.
They want more money. So, and when they sell the property, do you think owner number 1 is going to want to split this money up equally when they sell the property, or is owner number 1 going to want more money than the other 2?
They're gonna want
Gonna
more.
want more.
They're going to want more
money.
And so it's really important that we start to answer those questions of, well, who can use this property? Who owns what are the percentages? And then probably the most important one of all down here. And this answer is going to change based on the type of shared ownership these people have. Look at this question, because I don't think we ever really think about the importance of this kind of a question. Does everybody have to be in agreement when we're going to sell? And don't try to answer that yet, because we haven't gotten there. Here's what I'm going to tell you. There's some types of shared ownership where the answer to that question is yes. You cannot sell anything about the property unless every owner agrees that you're selling it. But there are some types of shared ownership where you can sell your portion of the property and you don't have to get permission of the other owners. People can go and come as they please. Well, obviously there are advantages and disadvantages to both. I mean, think about that for a second. If I own a property, let's say Seth and I buy a property together. If we own a property together, what's the advantage of if we set it up such that either one of us can sell at any time? What's the advantage of that? Talk to me. What would be the advantage of that for us?
Profit.
What do you think?
I don't see an advantage in everybody it being different.
Oh, you don't see an advantage. What if he doesn't want to sell and I do?
Right.
You don't think that would be an advantage for me if I had the freedom to sell without having to get his permission?
Oh, yeah.
Like sell your share of the property or the
Right,
entire
so-
property?
I mean, selling my share. What I'm
Oh,
saying,
Oh,
okay.
okay.
Yes, that
Yeah.
would be an advantage.
would that be an
Oh,
advantage
yes.
if I had the
Yes.
ability to sell my share without consulting him?
Yep.
Yes.
Yeah, that would be great.
Yeah.
For sure, because we may not agree. We may not agree. Here's the disadvantage to that. Could Seth sell his share to somebody that I really hate, and now I share ownership with somebody that I can't stand?
Yes.
Yeah.
That's the downside of having that freedom. See, when people buy property together, folks, they have to decide, are we going to have that freedom or are we not going to have that freedom? Are we going to have the ability for us to essentially act independently of each other and go and come as we please here? Or are we going to tie ourselves together and make it so that whatever one does, we both have to do? Those are decisions we're going to have to make when we have concurrent ownership. Is everybody kind of starting to clue in on what we're going to be discussing here? Is that clicking a little bit?
Yes.
Okay. Because it's not going to be automatic. What happens in some of these cases, these are choices that have to be made in a lot of cases. One of the biggest choices, in fact, not one of the biggest choices that shared owners will make. And before I even go into this, I'm going to throw a question out here for you because I want to get your brain headed in the right direction. When do you think these choices have to be made? Are these the kinds of choices that the owners get to make as they go along? Or are these the kinds of choices they have to make at the moment they take ownership of the property?
When they
The
take
moment they
Oh,
take
they take
They take
ownership.
ownership.
The moment they take ownership of the property, that's their shot. That's their opportunity. So the first decision that co-owners, so let's be clear, we're talking about more than one owner. We're talking about co-owners. More than one could be two. Could it be 22?
Sure.
Could we have 500 people own a piece of real estate together?
Yes.
Yes, there's no limit on the number. It's just more than one. So anytime we have two or more people who are purchasing a property together, the first thing we need to have them decide on is, do they want to include something called the right of survivorship? I'm going to say that again. The first decision that these new co-owners are going to have to make, because we're going to ask them to put it right on their deed. It's going to be on their deed. They're not going to get to come back later on after the fact. It's going to be on their deed. We want it right there, front and center on their deed. Is, are they going to have this right of survivorship? So let's talk about the decision they're making when they decide that. Is everybody clear that this is a decision that they're making, take ownership?
Yep.
Right? Here's the decision that we're asking these new co-owners to make. What do you want to happen with your share of this property's ownership when you die? We're asking these owners to decide at the moment they purchase the property what they want to have happen to their share of the ownership on the moment they die. Is everybody with me on that?
Mhm.
Yes.
Now, here's the thing. We're not asking them for like them to name an heir. We're not asking them to give me the name of your firstborn child or pick your, who you want to inherit your property. That's not the choice we're asking them to make. We're asking the co-owners a simple question. If something happens to one of you, do you want the ownership to stay among the group, or do you want that ownership to go to somebody outside of the group? I'm going to say that again. We're asking these new concurrent shared owners, do they want to have the ownership of the deceased person stay within the surviving group of owners, or do they want to have the ownership of the deceased person go outside of the surviving group of owners? Is everybody with me on that decision?
Mhm.
So,
Yep.
so let me just throw this out there as that hypothetical. We'll go back to the example I said with Seth and I buying a property together. If Seth and I buy a property together and we say, yes, we want the right of survivorship, and something happens to me a month later and I'm killed in a car accident, if we asked for the right of survivorship, what do you think would happen to my share of the property if we've said we want the ownership to stay within the survivors? We want the survivors to get the ownership. What do you think?
Good, it would go to Seth.
100%.
Seth is lucky.
It's
Go to Seth.
lucky.
They
That's
probably
exactly right.
Going straight to Saint.
That's exactly right. Now, here's why I said it that way of not, rather than just saying it goes to Seth, which is right, by the way, in this case, the way I like to say it is it stays with the survivors, because let's expand that. Let's say that Taj and Aaron and Trisha all buy property together and they ask for this right of survivorship. The three of them, is everybody with me so far?
Yeah,
Mhm.
And then Aaron is killed in a car accident. What's going to happen to Aaron's share when they said they wanted to have this right of survivorship? Her share is going to stay with the survivors, right? So what we're going to do is take Aaron's share and divide it up between Taj and Trisha. Is everybody with me on that?
yeah.
Yes.
Yes.
Now, the most common example of this is the marital relationship. This is the way it works in marriage without even asking for it. When you're married to somebody, it's pretty much an automatic function of the law that if you die, your ownership interest goes to your spouse. But it's not an automatic function of the law for that to happen when people are not married to each other. So anytime you have co-owners who know from the time they purchase the property that they want to keep the ownership just between them, no matter what happens, they would ask for what right?
Of survivorship.
survivorship.
The right of survivorship. So look at the example I've given you here. It says, let's say that Bob, Tom, and Sam all own a property together and have asked for the right of survivorship. Tom dies. Because of this right of survivorship, Tom's share of the property transfers immediately to Bob and Sam because they are the what?
The survivor.
Survivors.
The
survivors.
survivors, right? And look at that last statement, folks. Here's the test question. It's going to bury you if you're not careful. This is going to bury you on the test if you're not careful. It doesn't matter. It doesn't matter if they have a will that says something different than that. Survivorship is stronger than a will. If you die and you have survivorship, if Seth and I own a property together and we have this right of survivorship and I die and my will says my half of the house goes to my dogs, are my dogs going to get that half of the house, or is Seth going to get that half of the house? Which one carries more weight, the will or the survivorship?
The
Survivorship.
Survivorship. So survivorship is more important. It is stronger than a will. Does that make sense for everybody?
Mhm.
As a matter of fact, when you have this right of survivorship, we don't even bother to look at the will as far as that property is concerned, because it doesn't matter what the will says when it comes to that property. So this is a very strong statement that these two co-owners are making at the time they purchase the property together, that essentially, no matter what, they want the ownership. And this is why I used the logo from the show Survivor here, because if you've ever watched Survivor, how many people are winners in the end in the game of Survivor?
One.
Just one. Well, if you think about the right of survivorship, no matter how many owners you start with, how many owners are you going to end up with when you start with the right of survivorship?
One.
One. Because if you start with 4, one dies, you're going to end up with what?
3.
3. And you start with, and then you have 3 and one dies, you end up with 2, right? If you don't, now, Tyler has asked the question that everybody asks, and I always have to slap somebody on the back of the hand for asking that question, because Tyler has asked the question, if no survivors are left, there always are. They don't die at the same time. Even in your head, if you think that, how many of you knew this? If 400 people die in a plane crash, every single one of them is assigned a different time of death for this very reason, because we need to establish time of death. If we have 5 owners and they're all in the car together and they run off the cliff, whoever's death certificate said they died last, they're the one who owned the property, because they're going to go one by one, boom, boom, boom. Seth's share goes to Travis. Travis's share goes to Bud, until you're down to one, that one owner. And then, of course, once you're down to one, that person's will does matter at that point in time. Right? So you're always going to follow the order of the people dying, whatever order they were deceased in. When it comes,
I apologize if I'm a little reserved today, guys. These recaps are a little bit more strenuous to organize. So anyways, I'm here.
there's no excuses. Gosh.
I don't know who you're talking to. So Crystal had private messaged me until Seth dies. I think it was a previous example that we might be way ahead of right now, but sorry about that.
Actually, she was just kind of like wishful thinking, I think.
I think you are.
But that is the idea of survivorship. Is that clicking for everybody? These are 2 or more owners who, at the time they have purchased the property, have basically made a commitment to each other. They have said, so let's think about that for a second. Since this is such a strong commitment, do you think every group of co-owners is going to want this? Like, as an example, if you just have 2 business partners, they're not related to each other, they're just business partners, and they buy a warehouse together. Do you think they're going to want to have the right of survivorship? Now, before you answer, think about the implications of that. That means if one of them dies, that person's ownership in that real estate would immediately go to their business partner, not to their wife, not to their kids, not to their heirs. Do you think people like in that situation would probably want this right of survivorship, or are they probably like, I'll stick with leaving it to people in a will?
Yeah.
Right.
Right. They're not going to want the right of survivorship. How about married people? Are they going to probably want the right of survivorship?
Yeah.
Yes.
They already.
How about people who are not married, but are like dating or significant others or life partners? Are they probably going to want the right of survivorship if they're buying a house together?
Yep.
Yeah.
How about my mom and her sister who own a family farm together in Edgecombe County? Do you think now keep in mind, my mom has a child, her sister has a child. Do you think my mom and her sister would want this right of survivorship in this farm that they share together?
No.
No.
No, because if they did, I would have to go kill my aunt, because I'd have to make sure that my mom got the whole farm so that I would get the farm. That's not the dynamic we want to set up. We don't want to do it that way, right? So survivorship does not make sense in every situation, but it does make a lot of sense in some situations. How do we feel so far about that?
Good.
Yeah.
Okay.
Good.
Now, as I just said, survivorship is not always there. There's not always going to be this idea of survivorship. Lots of concurrent owners, for various reasons, don't want survivorship. Imagine if you've got 5 friends who buy a beach house together. Are they probably going to want their shares to go to their friends when they die, or are they going to want their shares to go to like their children and their heirs and people that they leave in their will? Which one?
Yeah.
The children, the heirs.
Probably their
Right.
heirs, right? So they probably don't want the right of survivorship. So it's going to be a case by case basis. People have to decide. And again, remind me again, when do they decide?
When they're buying
The
the
time
house.
they take ownership.
When the time they take ownership of the property. In fact, it's going to show up right there on the deed. So let me go back. I just want to go back for just a second. I'm going to see if I can pull up a screen for you and share it with you. I'll have to change my share here just a second. But
On
I'm
your
gonna-
deed, it said it
Yes.
said survivorship.
I'm sorry.
Yeah. Your deed.
There we
And-
go.
Your
That's
deed
the-
said right of survivorship.
That's exactly the deed that I'm pulling up to share with you right here. Look at my deed right there. Look at the grantees. It says Andrew Peter Charlin and Travis Robertson Everett as joint tenants. And look at what it says right there. With the right of what?
Survivorship.
Survivorship. When did we make that decision?
When you
And-
were purchasing it.
When you
When we
purchase
bought
the
the property. And so what have we told the world we want to happen if something, and no will is required, by the way. In fact, it wouldn't matter. If I wrote a will and wrote him out, it wouldn't matter, because the instant I die, what is this deed telling the world is going to happen with this house, this piece of real estate, the instant one of us dies?
And-
the other person.
It's going to go to the survivor. It's going to go to the
That be
survivor.
changed after the fact.
I'm sorry, what was that, Sheb?
That be changed after you already signed the deed.
Can it be changed after you've purchased the property? Only if you sell it to yourself again, because the only way you can do this is to have a new deed. That means a new transfer of ownership. That means you'd have to essentially sell it to yourselves. You'd have to agree to sell it to yourselves in order to change this choice.
Mm.
I
Okay.
asked because of the previous example of, being unmarried prior to being married with purchasing the property.
Right. So they could then sell it to themselves. They could be the grantors and the grantees and simply change the choice at that point in time. Okay. So are y'all starting to tie some of this stuff together now? Like, that's why that language is there. It's telling the world, hey, if something happens to one of these two, they want to make sure that ownership stays among them. Okay. So that is that right of survivorship. So let's talk about the three different types of concurrent ownership, and we're going to tie them back to this idea of survivorship, because one of these has survivorship all the time. One of these never has survivorship, and one of these pretty much always has survivorship. So we're going to go to the extremes, and then there's one sort of in the middle. Let's talk about the extreme of survivorship is always there in this one type of shared ownership. That is called tenancy by the entirety. You need to study this topic. This is a continual source of confusion for people on test. I mean, continual. People miss these more often than they get them right. I'm warning you on day one. You need to revisit tenancy by the entirety probably 26,000 times between now and the end of the exam, because you'll miss these questions if you don't. Tenancy by the entirety is the form of shared ownership between one very specific group of two owners in the state of North Carolina. It must be two. It cannot be 3 or 4 or 5. We are not in Utah. 2, because tenancy by the entirety.
Oh God, totally scratch this, what I just said.
Tenancy by the entirety is the form of ownership that is limited between a married couple. Now listen, stop writing and listen. I did not say that just because they're married, it's going to be tenancy by the entirety.
Correct.
Do not make that association in your brain. Derail that train off the tracks right now. Listen to me. Tenancy by the entirety is reserved for property that is purchased while these people are already what? What comes first, the property or the wedding? Which comes
The
first?
wedding.
The
Thing.
Wedding. These are people who are already married to each other, and then they purchase property together. The wedding came first. That's tenancy by the entirety. Why do I make a point of pointing it out like that? because it's not tenancy by the entirety if the property came first. Let me ask y'all this, and I'm gonna see if I got anybody in this situation. Do I have anybody in the class who has bought real estate, particularly a house, with their significant other who was not their spouse at the time? They may be their spouse now, but they were not married at the time they purchased the properties. Anybody in that situation?
Yes, me.
Claudia, you're in that situation? Okay.
Mhm.
So Claudia, when you bought your home, you and your significant other were not married.
Uh-huh.
Okay.
Yeah.
So good example here, folks. If Claudia and her significant other were not married at the time of purchase, are they tenants by the entirety in the property?
No.
No, they are not, because tenancy by the entirety is limited for people who are already married before the purchase takes place. Does that make sense for everybody?
Yes.
Yes.
Okay.
Yes.
Now, if they had purchased the property after the marriage, it would be tenancy by the entirety. You do not get a choice in North Carolina of how you want to own property with your spouse if you purchase the property while you're already married to them. Here's how the state looks at it. Before you were married, you got to make your own decisions. After you're married, there's no more you. There is the two of you. So when you purchase property and you're married, you are purchasing it as an entirety. You are purchasing it together collectively as a group that cannot be separated. That is what tenancy by the entirety means. Everybody with me on that?
Mhm.
Yep.
Okay.
So Travis, so that means, because I think that's where I am. So my husband and I got married, then we just bought a home. So that means that even the will doesn't trump that in North Carolina. It's automatically is what it is.
So I'm gonna make sure I got your question right. You said your husband, you just got married and then you bought the home?
Right. So
Okay.
we are entirety.
You are tenants by the entirety then, too.
Right.
You bought the property as a married couple in North Carolina. You are tenancy by the entirety. And so you're exactly right. Your will, as it pertains to that property, does not matter. It does not matter what you write on your will. It does not matter what he writes on his will, because by state law, as tenants by the entirety, you have invoked the right of survivorship. And what that means is that when one of you dies, whenever that happens, that person's share will automatically and immediately transfer to the surviving co-owner. Okay.
Mhm.
Russell asked, is this any and all property? It's any and all real property. Any and all real property. So this would apply to not just housing, but it would apply to investment property. It would apply to vacant land, anything that's real estate in the state of North Carolina. Now, let's go back to Claudia's example for a second. Does that rule apply to Claudia's situation, considering the property came first? No.
No.
Not. So assuming Claudia has not done anything to change it, we're just going to operate on the assumption that she hasn't changed anything since she's gotten married. Is her will going to be very important when she dies, even though she's now married, as it pertains to this property?
Yes.
Yes.
Yes, because so you need to understand this. This right of survivorship does not automatically kick in just because the two people suddenly married each other. It's either there when you bought the property or it's not there at all. Is everybody with me on that as far as survivorship goes?
Yeah.
Okay. So when people are married to each other and purchase property together, they are tenants by the entirety. Now, here's the other thing, and some people don't like to hear this, but it is true. If you are married at the time of purchase, it does not matter to the state of North Carolina whether your spouse is an active participant in that purchase or not. They own 50% of it if it is bought as a married couple in North Carolina. That is where the old expression comes from. It only takes one to buy, but it takes what?
Two
Two
to
to
sell.
Two to sell.
Do the sale.
Because, so let me tell you how that works, folks. I had to have this very tough conversation with a lady early in my career. She had gotten married right out of high school. They had separated like 3 months after they got married. They never bothered to get a divorce. They had not seen each other in 18 years. She had changed her whole life around. She had bought her own house in Raleigh. She's been working. She had just about paid the house off. She's ready to sell the house and buy a bigger house. And she comes to me and she wants me to list the house for sale. And so I took the listing and I started doing my research and I called her up and I said, "Who is Chad?" And she said, "Chad who?" And I gave the name. And she said, that's my ex-husband. And I said, "Oh, well then just send me a copy of the divorce decree and I'll make sure this gets updated because they don't have a divorce on file for you here." And she said, well, there isn't a divorce. We never got divorced, but we haven't seen each other in 18 years. I said, "Well, you're probably going to see Chad when you give him half your money from selling this house."
Wow.
Because she bought it when she was what?
Married.
Married. Which means Chad owns half of it. That is what Tenancy by the Entirety says. And so you have to be really, really aware of that implication. There is no, now, people ask me all this time, well, can I do something different? Yes, if you get enough attorneys involved, there's a way around that. Both spouses can agree to it. It's called a free trader agreement. You're not going to be tested on that. But it's a big legal maneuver to get around this tenancy by the entirety. And it has this automatic right of survivorship and it's automatically 50-50. So people, listen, let me just clear up all these questions that are going to ramble around in your head. Well, what if I made all the mortgage payments? Does that matter?
No.
Not at all.
No. Well, what if we use my money that my mama left me when she died and he didn't have any money? Does that matter?
No.
Everything does not matter in ownership.
Not at all. Not at all when it comes to tenancy by the entirety. So this is a very ironclad. There's a reason those rings are made out of metal. Like, you know, they just put them in the wrong place. They should be around here instead of around your finger. That's sorry. You know, tenancy by the entirety is a very, very sort of regimented form of ownership, right?
Travis,
I'm sorry, go ahead.
did you say that even if a spouse, say for instance, your spouse went ahead and purchased a property without even your name on the deed, and they go to sell that property, you get a half of that as well?
That is exactly right.
On the deed.
That is exactly right. Even if your name's not on the deed, even if they try to do it on the slide, because when we get ready to sell that property, guess what? The first public record we pull on every seller on that deed is their marriage records and see if they're married. And if they're married, we're going to want to see that spouse's signature on that deed conveying ownership.
Travis, I may be answering my own question here, but I purchased a home while single. Before he was my husband, boyfriend, fiance, whatever, moved in. At the time of him moving in, we refinanced, but did not change any names on the deed. Where does that put us? We refinanced together and added his name.
The financing has nothing to do with ownership. So you bought the property by yourself or you bought it with him?
No, by myself 6 years ago.
All right. And
we recently got married.
And then you got married. When the ownership transferred when you got married, your spouse has what's known as a marital interest ownership. Now, that is different than tenancy by the entirety. That's an unknown amount of ownership. So basically, your spouse has some unknown amount of ownership in that piece of property. The only way, you don't want to find out how much ownership your spouse has, because there's only one way to find out: divorce court. If the only way you'll ever, because here's what the law assumes. The law assumes that you're going to remain a happily married couple. And if you ever decide to sell that property, you're going to share the money and there's not going to be an argument about it.
Right.
But if you were to get divorced, the court would have to decide how much of that money he's entitled to, how much of that property he's entitled to, because the marriage does grant him some ownership interest in the property.
Okay.
So it's an unknown amount. It's not tenancy by the entirety though, because it's not that guaranteed 50-50 and it doesn't have the right of survivorship and all those things.
Okay. Thank you.
Now, I do want to point out, we can create tenancy by the entirety after the fact. If you want to, Summer, you can make your husband a tenant by the entirety. Now, that would be very nice of you in this case, if that's what you would like to do, but it would certainly be a gift from you if you were to do that. Because right now your husband has some unknown amount of ownership. A judge could say, look, she bought the house before you don't get anything. Judge could say, well, you know what? I think he's entitled to 20% of the value of the property. Or a judge could say, oh, I think he's entitled to half of the value of the property. Or you could guarantee that your husband would get 50% of the property, and you could lock in this right of survivorship, because you could sell the property to yourselves. You and your new husband could be the grantors on a deed and the grantees on a deed. But on the new deed, since you're now husband and wife, at the moment you take ownership on the new deed, you would be what? Tenants by the what, folks? Help me out.
Entirety.
Entirety.
Tenants by entirety.
It's by the entirety. So you can make the decision to change it if you want to, but it is not going to automatically. It is not going to automatically happen. And yes, of course, prenuptial agreements can counter these things, but that's beyond our scope in this class. We're talking about how things operate when people don't have specific legal agreements. If people have gone to the trouble of having prenuptial agreements, then they're going to know exactly what's going to happen with their property rights, because they've talked in detail to an attorney about that. So look at this example right here. It says Tyson and Charlotte were married in 2018 and have recently purchased a home in Charlotte. Charlotte provided the entire down payment and Tyson will make the monthly payments. In this case, the information about who made the down payment and who will make the monthly payments is useless. Tyson and Charlotte are tenants by the entirety, and we know that because they were already what when they purchased?
Married.
Married, right?
Married.
So they're tenants by the entirety. That means they each own the property together 50-50, and they must do everything relating to the property together, which brings us to a very important point. Can Tyson and Charlotte sell their share by themselves, or do they have to operate as a team in this thing?
Operate
As a team.
To operate as a
They have
team.
to operate as a team. They cannot independently make decisions of each other when they are tenants by the entirety. That is one of the major limitations of tenants by the entirety. Okay. Now, I cannot stress enough this note right here. If two people own property together before they get married, getting married does not change the form of ownership. However, getting divorced does change the form of ownership. If two people buy property together as a married couple, when they get divorced, most of the time, they're not going to continue to own the property together, but they could. That's possible. Some people just have, like as an example, Leslie, who was here earlier, her mom and her dad are divorced and they still own the house, their marital house. They still own it together, and they've been divorced for like 15 years. And I don't know why. It's the weirdest thing I've ever heard of too. I just don't know why you would do that to yourself, why you would continue to own property with somebody you hated enough to divorce anyway, but they decided to do that. If the former couple decides to continue to own the property together, they cannot remain tenants by the entirety because they're no longer married. So they will have to change their ownership to something else. We'll talk about what their options are here in just a second, but they cannot remain tenants by the entirety. So getting married does not change the form of ownership, but getting divorced would force a change in ownership if you were tenants by the entirety. Everybody okay with that? And yes, this is North Carolina specific. This is how we handle property law, but this is also the reason I don't have the North Carolina state flag on here is this is how this is going to be tested in the national section of the exam. North Carolina's method of handling tenancy by the entirety is the most common method nationally. And so this is the way this will be tested on the national section. And it will be. Very much so.
Sorry, can you repeat that statement again?
I just said that this is the way, yes, this is how we practice tenancy by the entirety in North Carolina, but this is also the way it's going to be tested on the national section of the exam.
Thank you.
So if somebody is a single property owner, they own the property before marriage, and then they get married. Let's talk about what happens. This is Summer's situation. The minute Summer got married, she lost some ownership of that property. That is called a marital ownership transfer. The minute they said I do and they were legally married, there was a transfer of ownership from Summer to her spouse. The issue is we don't know how much. North Carolina is not a state that has some pre-listed, oh, it's this percentage or it's that percentage. Some states, like for example, California off the top of my head, practice a form of real estate that basically says whatever you own before you got married is what you own, and whatever they own before they got married is what they owned. And when you get married, it doesn't change anything. That is not the way it works in North Carolina, and that's not the most common way nationally. The most common way nationally is this marital ownership interest, which unfortunately is murky. As I told Summer, the only way you'll ever find out how much ownership was transferred is through the divorce process. So hopefully you never have to find out. You know, in fact, I recently had one of these that I was helping. And they were going through a divorce, and it was a situation where he owned the home before they got married, and she was the one who contacted me to help represent her in finding a new house. And so I was hearing all about the selling of the old house, and she ended up getting 70% of the proceeds from the old house, even though he owned it by himself previous to. And all I said to her was, he must have messed up real good for a judge to do that. And she said, oh yeah, I had pictures. I said, okay, enough said. Got it. Heard, understood. But that's that marital ownership interest. It basically leaves it up to the discretion of a judge. Whereas tenancy by the entirety is 50-50. It's a guaranteed 50-50. If people buy property as husband and wife, and then they get divorced, how are we going to split up the money?
50-50.
50-50. No matter how they paid, it's 50-50. But if people owned it prior to marriage, then it becomes up to the judge, and they're going to decide what they want to do. Does everybody see the difference there?
Travis.
Yes.
Even in North Carolina, since it's a 50-50 state, that doesn't mean that you automatically, because I own my own house, if I were to get married again, he wouldn't have a 50-50 interest.
That is correct. If you own your house before marriage and you get married again, your new spouse does not have a 50% interest. They have this unknown, it could be whatever the judge decides interest.
You would have to go to court to find out?
Well, you'd have to get divorced. Your actual divorce decree would line out and say, okay, this is what percentage we're allocating of the property to this person, and this is the percentage we're allocating to this person. It would be the actual divorce decision that would do that.
Can you add your spouse to the deed at any time?
You can. That's what I was saying to you.
Okay.
You can sell the property to yourself.
That's what you have to do. You have to go through that whole thing.
Exactly.
Okay.
You just go to an attorney and you say, we want to be tenants by the entirety, because here's what the attorney's going to do. They're going to draw up a deed. The deed transfers ownership, right?
Mm-hmm.
And the deed that they draw up is going to show you and your husband as grantors, but not as tenants by the entirety. And then it's going to show you and your husband as grantees as tenants by the entirety. So in
Okay.
essence, now you've locked in that it's 50-50 and this right of survivorship and that you're now tenants by the entirety.
Okay, got it.
So you don't have to do a contract and that whole
Nope.
rigmarole. Okay.
Nope. Yeah, it can be done in a day. As a matter of fact, to give an example of this, that I helped people with several years ago, when the Supreme Court decision legalized same-sex marriage, I had quite a few clients over the years who had purchased property together who were married in other states, but North Carolina did not recognize their marriage. And so they were not tenants by the entirety in their property that they purchased here because the state of North Carolina did not recognize their marriage. Well, once the Supreme Court decision, the Oberfeld decision, changed that, their ownership didn't change automatically. They had to redeed the property to themselves. So I went back through my records and I found, and I think it was 10 or 11 of them that I had that case. And I paid an attorney to redraft deeds for them. And I sent them a note that said, listen, if you'd like the state to recognize you as tenants by the entirety because of your marriage, all you got to do is show up at this attorney's office and sign. They'll notarize it for you. I'll pay the recording expenses, and then you'll be tenants by the entirety in your property. It's the single best way. I mean, you know, that you talk about clients for life. When you think about that sort of thing for people, you know, and so now they literally have on their deed being recognized fully as a married couple where they were not before. You can't buy that kind of marketing for yourself, you know? So, you know, but that's understanding how the laws work. Everybody feel okay about this tenancy by the entirety thing?
Yes.
Okay, good. Now, lots of co-owners are not married to each other. In the event we have co-owners who are not married to each other, they have to make a choice. Do they want this right of survivorship? Now, remind me again, don't lose track of the big stuff. What does the right of survivorship deal with? It said the right of survivorship says that we want the ownership to stay within this group, right? We want, if something happens to one of us, we want the surviving owners to sort of absorb our share. If co-owners are not married to each other, they have a choice to make. Do we want this right of survivorship or do we not want this right of survivorship? And for your purposes on the test, that's going to be a simple thing. If they want the right of survivorship, they're going to choose joint tenancy. Joint tenancy is the type of ownership that is chosen by two people or more who are co-owners who are not married to each other at the time of purchase, but they wish to have the right of survivorship between them. Is everybody with me on that? I'm going to say it one more time. Joint tenancy is the type of ownership that should be chosen when you have two or more people purchasing a property together who want to have the right of survivorship in spite of the fact that they're not married to each other. So could we have 5 people purchase together as joint tenants?
Yes.
Yes, 2
Oh,
or
we
more.
can?
Yeah.
Okay.
It's not limited to a number like tenancy by the entirety is. We could have 5 people. And if we had 5 people who were joint tenants and one of them died, how many owners do we now have?
4.
4. And if one of those dies, how many do we now have?
3.
3, because that share keeps getting absorbed by the smaller and smaller group of survivors until we get down to what?
1.
Until we get to 1 owner. And then the joint tenancy is over, because at that point you just have ownership in severalty. Does that make sense for everybody?
Yes.
Okay. And of course, once you get to ownership in severalty, the property is going to transfer to whoever that the heirs are of that 1 owner in severalty. Okay. Now
So
in North Carolina, we do put this, we do say you have to put with the right of survivorship on the deed. But the truth is, nobody asks for joint tenancy unless they want survivorship.
So in North Carolina, what really helped same-sex couples then was this joint tenancy with right of survivorship, because otherwise, if you didn't have that, then there would be the heirs and the parents and everybody else coming in and wiping out the partner.
There's a reason my deed says that.
I bet.
He's been putting up with me for 15 years. You better believe if something happens to me, I want to make sure he gets the other half of this house. And here's the thing, I don't want a will getting in the way of that.
Right, because those can be options, can be subject to interpretation.
Well, that's exactly right. And how, if for those of you that have dealt with the will process, can it take years to probate a will sometimes?
Yeah.
Right. See, survivorship makes this an instant transfer. So if something happens to me or if something happens to Drew, this is instantly going to transfer ownership among the two of us. Does that make sense for everybody?
Yep.
Correct.
Makes sense.
That's
Before there was same-sex marriage, this was all there was.
well, that's exactly right. This was it. This was as close as you could get. This is as close as you could get. That's exactly right. Now, so that's joint tenancy. Now, I will point out something though. It's not tenancy by the entirety. Look at this statement right here. And this is the one, and y'all don't tell Drew, because sometimes when he gets pissed off at me, I swear he's going to do this to me one day. Joint tenants can sell their share without the other person's permission.
Yes.
Or will it?
They can do that. And they don't have to, so, like in theory, if he was really mad at me, he could sell it to somebody I really hated for $1 and I'd have to live with him. Does that really ever happen? Probably not, but it could. The other thing to point out, and this is going to be important for test taking purposes, is this note up here at the top. It says anybody who wishes to be a joint tenant must have purchased at the same time as all the other owners. Because we allow this, some owners can sell their share without the other owners. Basically, you start trading places. So like, as an example, I'll just throw this out there as an example. Let's say that for whatever reason, Drew and I decide one of us wants to sell our half of the house. And let's say I want to sell my half to Drew's brother. Legally, I can do that without Drew's permission or with his permission. Doesn't matter. Either one works. Okay. The thing, though, is Drew's brother could not come in as a joint tenant because this rule says that the only people who can be joint tenants are the original group. You have to be part of the original group, the original purchasers, in order to be a joint tenant. Do I need to say that again, or does everybody agree with that?
So that means if there are 5 people and one of them sells their share, then that person who bought that share only has ownership of that property until the last original person passes?
No, you're making it more complex than it is. It means that new person cannot benefit from survivorship. So that new person coming in will not benefit from the other people dying. They won't take part in that, that reconcentrating of the ownership. So take the 5 owners. You got 5 owners and they have the right of survivorship. One of them dies. Now you have 4 owners. Their share got bigger, right?
Right, because it's less than.
If you take because now there's only 4 to share it with. Let's say one of the 4 sells their share to a new person. That new person comes in and they're going to be an equal co-owner with the other 3. But now when one of the original 3 dies, their share is going to only stay within the original 3. Gotcha. That new co-owner does not benefit from this right of survivorship. Their share is going to stay locked in at that amount that they bought in at.
They didn't buy all at the same time.
Because they didn't come in at the same time. They're not going to benefit from this whole, we decided to keep it amongst us thing.
So their share will continually decrease.
It'll stay the same. Their share will stay the same.
But it never increase.
It'll stay the same, but it won't increase the way everybody else's does as people die.
Okay.
So the one who came in after the fact wouldn't benefit from other people dying, and neither would they benefit from him dying?
The ones, so he would not, the new owner would not benefit from any of the originals dying, and they would not benefit from him dying. That is correct. That's exactly right. And I did not hear you earlier, or whatever it was. I didn't hear that. So sorry about that. But yeah, that's the kicker here with joint tenancy. They all, in order to be a joint tenant, you have to have come to the party at the same time. other people can buy in, but they can't buy into the real benefit of joint tenancy with it, which is that right of survivorship.
What if the latecomer owner dies? What happens to his shares?
Their share goes to their heirs. Either when you die, either your share goes to your survivors with joint tenancy, or it goes to your heirs. Those are the two choices. So their share would go to their heirs. Okay.
So their share can go into probate?
Yes, their share would go into probate when they die, if they're not a joint tenant. That's exactly right. That's exactly right. So look at these notes here. It says a joint tenant can sell their share of the property's ownership at any time, whether co-owners approve or not. I don't know why that's there. Let's see if we can fix that. Yeah. The new owner is too late for the joint tenancy. They come in as something else. So, I mean, think of it as like a clique at lunch. You know, you go in and you sit down with 4 people at your table. Somebody else can come and eat a sandwich, but they can't sit with you. We're going to put them off to the side. They don't get the benefits. They weren't there from the beginning. You know, we can't control whether or not they become an owner, but we can control whether or not they're really part of the group. And so they're not going to really be part of the group. They come in as what's known as a tenant in common, rather than a joint tenant, because they're not going to participate in the survivorship part of the thing because they were not there from the very beginning. That's the big drawback there. So this is how I have for years taught my classes to remember this on a test. You would never pass a joint to your heirs. You would just not, and if you would, you're a weird person. You would never pass a joint to your heirs. So don't, on a test, if you figured out that somebody is a joint tenant, the answer is not that their share is going to go to their heirs. If they're a joint tenant, their share is going to go to the surviving other joint tenants. You only share the joint amongst the people who put in on the joint in the first place. Does that make sense? So if 4 people put in on the joint, they're the only ones who get to participate in it. If one of them drops out, that's fine, but don't expect the new one to come in and play with the joint. That's not happening, okay? You keep it within the group. So if you were sharing the joint with 4 people and one of them drops out, now you're sharing the joint with what?
3.
With 3 people. And that's just the way it is with joint tenancy, you know? That's what it is. So joint tenancy is going to stay within the surviving joint tenants. Now, Tyler asked a question, right? If there are no survivors left, then does it go to heirs? Yes, eventually, when you get down to the one last remaining joint tenant, now survivorship is done and we go to heirs. I'll say that again. When you get down to the one last survivor, the one last of the original joint tenants, that's the end of survivorship. And from that point forward, we're just going to deal with heirs and wills. Everybody okay with that statement?
Yes.
Okay. Now, so look at this example right here. It says Vance and Corey have decided to purchase a warehouse together and wish to make sure that ownership stays within the 2 of them. They have purchased the property as joint tenants. This means that if Vance were to die, his share would automatically and immediately go to Corey because of the right of survivorship. It does not matter in this case if Vance has heirs, if Vance has a spouse, if Vance has children, if Vance has a will or anything else. His share can only possibly legally go to who when he dies?
Corey.
To Corey. Because now listen, we're not talking about all of Vance's stuff. We're just talking about his share in this one piece of real estate that they became joint tenants together on. Does that make sense for everybody? We're not talking about like every worldly possession that Vance has. We are literally just talking about this one warehouse that the 2 of them have purchased together. And in that case, it would go to the surviving joint tenant, the one that's still alive. Now, if the concurrent or shared owners are not married to each other, which would be tenants by the entirety, if the concurrent or shared owners don't choose survivorship, which would be joint tenancy, we are left with the one remaining choice. So these are people that we know two things about. What are the two facts that we know about these people that we're about to talk about? Number one, they are not what to each other?
Related.
They're not married. They might be related, but they're not what?
Married.
Married. They're not married to each other. And number two, when asked, do you want the right of survivorship or not? Their choice was what?
No.
No. Those people become what we know as tenants in common. Tenancy in common is the form of ownership. It's the loosest form of shared ownership because it basically
is doing that.
It basically says these people are not tied together in any way other than the property itself. They do not want their shares to stay within the group. As a matter of fact, they specifically have said they don't want their shares to stay within the group. What do you think they're going to have? I'm going to go to the next slide for a second. What do you think there is going to happen with a share of a tenant in common when they die?
It'll go to their heirs.
It's going to go to their heirs. That's exactly right. It's going to go to their heirs. So anytime on a test you see a tenant in common dying, what's the answer going to be? Their share goes to their what?
Heirs.
Now let's talk about that word heirs for a second, because here's what I've come to learn in this class. You all like to separate heirs into categories that really shouldn't happen. Folks, heirs means anybody who inherits your stuff. Heirs could be your children. Heirs could be your spouse. Heirs could be your girlfriend that nobody knows about who lives down the street, but you put her in your will. Heirs does not automatically mean family. It means anybody who stands to inherit your stuff. Where do we look first to see who inherits stuff? This is another reason why people make assumptions that are wrong about real estate. Do family members automatically inherit stuff, or could a will specify somebody other than a family member inherits?
A will.
A will could specify somebody other than a family member. I went to college with a guy from Carolina, and he used to always walk around talking about how much money he was going to inherit from his dad. His dad was like 60 when he was born, and he hated his dad and how much money he was going to inherit from his dad. And that was the only thing his dad was good for, is how much he was going to inherit. When his dad died, he left him $10.
No way.
Out of an estimated $30 million estate.
Yikes.
And first of all, I laughed when I heard it. I shouldn't have, it's evil, but I did. But I remember thinking, $10, that's a very specific amount. And an attorney friend of mine spoke up and said, Travis, you don't understand the significance of that. If he had left him out of the will, the kid could have gone to court and contended that his dad just forgot, that clearly he didn't mean for that to happen, that obviously nobody would ever leave their child out of the will inadvertently like that. By leaving him specifically $10, he made it clear that he had not forgotten him, and that's all he wanted him to have.
Wow.
So wills, folks, do not necessarily mean the closest living relatives. Wills mean whoever that person has named as their heirs. So keep that in mind when you're taking the test. If it says their will says this, what's the one thing, the only Thing that can override a will that we've talked about?
Survivorship.
Survivorship is the only thing that can override a will. And if you've decided that it's joint tenancy, which means survivorship, don't worry about what the will says. If you've decided that it's tenancy by the entirety, don't worry about what the will says. But if it's tenancy in common, is the will going to be very important?
Yes.
Yes. No doubt. Now, I did give you, because people commonly like to ask, people always want to know, okay, well, if you die without a will, how's the state going to decide to distribute your stuff? And so I've given you the list that currently the state of North Carolina uses. Of course, they could change this at any time if they really wanted to. This is the sort of pecking order that the state of North Carolina uses. It's called the law of intestate succession. If you die with a will, you die testate. If you die without a will, it's called intestate. And so the law of intestate succession in North Carolina currently says that the first line of inheritance, if you die without a will, this is only if you die without a will. So it's almost like a pecking order. First, when somebody dies, first thing we look with the property is, do we have the right of survivorship? Second thing we look at, if they don't have the right of survivorship, we look, okay, do they have a will? If they don't have survivorship and they don't have a will, then we go to this list of people. And the first person on that list is any living spouse. Second person or people on that list, any living children, and then living parents, and then living siblings, then nieces and nephews, and then first cousins. There is one other potential heir down here at the end of the list that I did not list because it pains me to put them there, and we'll actually talk a little bit more about this later. There is somebody else down here at the bottom. If they've worked all the way through this list and they can't find any of those people, there is one heir down here that all of you have. They're the last one on the list. So if you die without a will and the state works through that list and can't find any of those people, then they will step up and say, you know, it's such a horrible thing, but we have to take this stuff. And they
Can
will.
I ask a question really quick?
Sure.
Look, you know, my brain processes differently. So in this case now with this list right here, will they say go in, or let's say there's a spouse and there's children, will they take those people and divide that, or they're going to go with the first? Okay, so it's going to be whoever's first in line. So let's say, for instance, you know, grandma, grandpa, whatever, they die, one dies, then the other one dies, but there's no will. So now you have a child. And so the child comes.
So when grandma died, grandpa got it all. Now, when grandpa dies, we're going to go to the children. And if there's one, that child gets it all. If there's two, they're going to split it equally.
And that's okay. Yep. Okay, got it. Thank you.
That's right. That's exactly right. And so, you know, when you get to this, it can get to be very petty. And that's why people should die with a will, because that way you follow their wishes rather than the state setting up this list for you. So anytime on the test you're asked about tenants in common dying, what's your answer going to be? Their share goes to their what?
Heirs.
Heirs.
Anytime you're asked about a joint tenant dying, what's your answer?
Survivorship.
Their share goes to the surviving joint tenants, whoever's left surviving that is a joint tenant. And if a tenant by the entirety dies, what's going to happen with their share?
The survivor.
Their spouse. Go to the one surviving spouse. Okay, those are your answers always for what happens at the time of death when somebody is a concurrent owner, depending on the type they have. So look at this one. It says Barry, Kathy, and Doretha purchased a property together in 2010 as joint tenants. In 2014, Barry decided to sell his share to Terry. First of all, can Barry do that? Can Barry sell his share? What do y'all think? Yes, right. What's the one form of ownership where we would say, no, you can't sell your share. You got to get the other person's permission.
Tenancy by the entirety.
Tenancy by the entirety, right? Tenancy by the entirety is the only one where you can't sell your share by yourself. Okay.
I just want to clarify, because I did hear survivorship. Just because you have survivorship doesn't mean that the share can't be sold.
Right. Absolutely.
It's tenancy by the entirety, the specific type of concurrent ownership where you can't sell the share without the other's permission.
Thank you. Thank you for that clarification, because that is exactly right. So Barry has decided to sell his share in 2014 to Terry. In June of 2021, Doretha died. What is the current status of the ownership of the property? Now, I'm going to show you. Now, this is broken down into a bunch of questions, and I'm going to go through it that way, but I'm also going to show you the way I would do this on a test for myself. look at the first question. When Barry, Kathy, and Doretha purchased the property in 2010, what share did each of them own? If they're joint tenants, what do we most likely know about the shares?
They're equal.
Split
Equal.
They're equal, right? So they each own 1/3. Does everybody agree with that?
Agree.
Mhm.
Yes.
Okay.
How would you split that up though? It's not a perfect 100%.
33.333. Is that what you're asking?
Yeah, that's what I'm asking. Because not a perfect 100%. So how would you split that?
Yeah, it's 33.33333. Yeah. The rounding, it would be so close. Did they have survivorship in 2010?
Yes.
Yes, they did, because it said they
Joint.
purchased as what?
Joint tenants.
Joint.
Joint tenants. So that means survivorship. Is everybody good that means survivorship? Everybody good with that?
Yeah.
Is Barry allowed to sell his share to Terry?
Yeah.
Yes.
That's a yes as well. Okay. Will Terry, who's the new person, the new kid on the block, will Terry be a joint tenant, or must she be a tenant in common?
Tenant.
Common.
Tenant in common. Now, here's what I want to point out to you. We've got Kathy and Doretha still there. Are they still joint tenants, or are they also tenants in common?
Joint.
They're
Joint tenant.
They're still
original.
joint tenants. So here's what this thing looks like now. If we draw it as like a pie chart, and we've got it in 3 pieces here, okay? We've got the part that was first owned by Barry, and then we've got Doretha here, and then we've got Kathy. Okay, and Doretha is a joint tenant, right? And Barry is a joint tenant, and Kathy is a joint tenant, correct?
Mhm.
Yes.
Correct.
Now, what they've told us is that Barry sells his share to Terry. And we said that could happen.
Yeah.
But Terry cannot be a joint tenant. Terry is a what?
Tenant in common.
A tenant in common. So now let's look at the last question over there then. What happens when Doretha dies? Now, Doretha is a what?
A joint tenant.
Joint tenant.
tenant.
So you would never pass a joint to your heirs, right?
Right.
Right.
So Doretha's share is not going to her heirs. Can we agree with that?
Yeah.
Right.
Yes.
So Doretha's shares is going to go to the other surviving joint tenant.
Kathy.
How many other surviving joint tenants are there?
One.
One. So what happens, it looks like to me, is Doretha's share
It's like
Says
67.
Kathy.
66.
goes to Kathy, right?
Mhm.
And so to me, what the ownership is going to look like after this is going to be something like this. You're going to have Terry up here, and then you're going to have Kathy on all of this, right?
Yeah.
How we all feel about that?
I have one question, Travis. Now that Kathy is here, no more joint tenants available. Now,
That's
if
a
she
great
dies,
question. And that Taj's question and Colin's question in the chat are pretty much the same question.
Oh.
At this point, is there any more joint tenancy, folks? What do y'all think?
no.
No.
No, because there's nobody else to participate in the survivorship. Once you're down to only one joint tenant, the joint tenancy has done its job. Does that make sense for everybody?
Yes.
So at this point, and so the follow-up question, if Kathy dies, what's going to happen to her share?
It goes to her heirs only
It
for
goes to her
that.
heirs. If Terry dies, what's going to happen to Terry's share?
Goes with
Goes to
theirs.
her heirs.
Goes into her heirs. That's exactly right. Because at this point, the joint tenancy and the survivorship are exhausted. They're done. They're done.
There's one thing that I got a private question about. So in joint tenancy, is it equal possession as well as in tenants in common?
So does joint tenancy have equal possession? Yes, that's a really great question. Joint tenancy and tenancy in common and tenancy by the entirety all have equal possession. Here's what equal possession means. If you are an owner of the property, you have the right to possess or occupy the entire property. So when we say, here's what we mean by that. Can Dorothea occupy a third of this property, or can she occupy the entire property?
The entire property.
The entire property. Can Kathy occupy the property a third of the time, or can she occupy the property all the time?
All the time.
All the time. These percentages only matter, folks, if they're collecting rent or if they sell the property. That's the only time these percentages matter. Because otherwise, any owner, even if you only own 2%, guess how much of the property you get to use?
All of it.
All of it.
All of it. And guess how much time you get to be there if you only own 2%?
All of it.
All of it.
All the time.
So Travis, it doesn't matter. It doesn't have to be equal shares when we start. Somebody can own 10%, somebody can own 30%, somebody can own 70%, right?
That's right. But it only work. But you would only do that if they specify it.
Right.
Right. The assumption is always if they don't specify that they're equal.
Okay, then but they would all have equal access to the property.
That's right. They would all, even if this had said Barry owns 10% of the property, Kathy owns 50% of the property, and Doretha owns 40% of the property purchased together as joint tenants, they would all have equal access to and use of the property as an owner. The percentages would not matter in that regard. And Yasmin, I think I answered your question, but just to be clear, yes, if either Kathy or Doretha die at this point, I mean, if Doretha dies at this point or Terry, then their share would go to their heirs. Now, if Kathy dies while there's still a surviving joint tenant, then it goes to the surviving joint tenant. So it really depends on who's left surviving when you die. If you have other joint tenants that are still surviving when you die, your share is going to go to the other joint tenants who you're a joint tenant with. If there are no other joint tenants, then your share is going to go to your heirs. If you're a tenant in common, your share always goes where?
Survive.
The heirs.
Heirs. Tenancy in common does not have survivorship. So if you're a tenant in common, your share always goes where?
Right. To your heirs.
Your heirs, right? Always, always, always. Any tenant in common. So I want you need to put that in your notes. It's already there on the slides, but you need to put it in a way that makes sense to you. Tenants in common, their share always goes to their what?
Heirs.
Heirs. Tenants by the entirety, their share always goes where?
To the surviving spouse.
To the surviving spouse. Joint tenants, their share goes to the surviving remaining joint tenants until there are no other surviving remaining joint tenants. Okay. That's going to be the difference. Okay. And yes, the use questions, exactly. It does not matter. These percentages do not matter when it comes to use or occupancy or time or any of those things. It matters for two things. Either when you sell the property for distribution of the proceeds from the sale or rental income. Because if somebody owns 50% of the property and another person owns 20% of the property, if we're collecting rent, we're going to divvy the rent up with those percentages. Okay, so this is just a recap of all those. If we have ownership in severalty, we only have how many owners?
One.
So when an owner in severalty dies, what's going to happen with their share?
It's their heirs.
It's going to go to their heirs. That's an automatic. Tenancy by the entirety. How many owners do we have? Guaranteed.
Two.
Do they have survivorship?
Yes.
Yes. So when a tenant by the entirety dies, what's going to guaranteed happen with their share?
Goes to their surviving spouse.
Goes to their surviving spouse, right? Joint tenancy. It could be two or more owners. Do they have the right of survivorship if they're a joint tenant?
Yes.
Yes, we can assume.
And so therefore, since they are joint tenants with the right of survivorship, when a joint tenant dies, what happens to their share?
Goes to our surviving joint
Surviving
tenants.
owners.
It goes
Otherwise-
to the other surviving joint tenants, not necessarily all the owners, because there may be some tenants in common sprinkled in there, right? And they
True.
don't get anything. It goes to the other surviving joint tenants until you get down to only how many joint tenants? What survivors you can always
One.
take it down
The
to?
last survivor.
One.
The last surviving joint tenant, and that ends the joint tenancy and ends the survivorship. When a tenant in common dies, their share always goes where?
To the
Their heirs.
To their heirs.
Heirs.
Make sure you come back and revisit those, because those questions will be asked on the test. You also have a worksheet about this that's in Learn Test Pass that you'll need to work on. Yep, that'll help remind you of some of this stuff.
And a quiz.
Yes, and there's questions in the quiz about this.
So when
Here-
someone gets married after the purchase, they become joint tenancy.
No, if they're married after the purchase, they have that marital interest. Remember, they're in that gray land. They're in that, they're not, they don't fit in any of these categories if they get married after they purchase the property. That's why you hope you never find out what kind of ownership they have, because the only way you find out is if they got divorced. The idea there, Kayla, is if they're happily married, when they sell the property, we're not going to have to worry about how to divvy up the money. They're a happily married couple. We only have to worry about a fight over the money if they're not a happily married couple anymore. And so we only bother to figure it out if they're getting divorced.
Okay, that makes sense.
And also, Tree, I'm so sorry. Also, Kayla, to clarify on that. So if I was to buy a property and then I got married after I bought that property, I would still own it in severalty with a marital interest.
That's right. That's exactly how the courts would refer to it. Seth Thomas is the owner in severalty, and then they would name the other person and say, and this person has a marital ownership interest. Okay.
Thank you.
Yep.
So question,
Oh, wait.
sorry, really quick, Travis. So going back to, let's say, you know, okay, everybody dies. There's nobody left. So besides a parent, let's say it's a parent. No, let's just say.
Oh, wait a minute now, back up. When you say everybody dies, there's nobody left, do you mean there was an owner in severalty and they died,
Owner.
or what?
So okay, so if we have a couple.
Okay.
And they get married after they buy the property.
All right. So what did they buy it together as? You got to give me that information then. Did they buy it as tenants in common or joint tenants? Which one did they choose?
I don't know.
Well, I mean, sure question. It's not mine. So that's what I'm saying. They had to make that choice when they bought the property together, whether they're going to be tenants in common or joint tenants. You can't possibly answer the question you want to answer, which is 20 years in the future, without knowing what they did when they first bought the property together.
So if you're trying to help a client, you would have to, knowing that knowledge, you would have to, guess where your research comes in, going back to even knowing how they purchased the property when they did the paperwork and stuff.
That's exactly right. But again, here's what I would ask you. Why do you care whether they were purchased the property as joint tenants or tenants in common? Are they getting a divorce?
They're both deceased.
They're both deceased. Well, did they both die in a calamity at the same time, or did one of them die first?
One died first.
So then that ownership transfer is already going to be taken care of. You're going to be helping the one who is now the owner of the property after all that's been settled out by the courts.
Okay, so there has to be, so what I would say, if there is it automatically or transfers, or is there something that needs to be done? Let's say the sibling comes in, they're like,
it only automatically transfers if they have what right? You're making it way harder than it is. It goes back to that original choice they made in the beginning. What right did they have to ask for if they want that transfer to be automatic? Survivorship.
They don't have,
If they didn't ask for survivorship, then there's nothing automatic about the rest of that process from the rest of the way. They're going to have to deal with the courts, and it might take 20 years to sort out who owns that property.
Oh, wow. Okay.
Good question.
Okay.
And that's the problem, Tia. You're trying to engineer it from the end. It happens in the beginning. If they were dumb enough to purchase this property together without the right of survivorship back then, and I don't mean to insult them, they should have How many of you all now think the real estate agent takes on a whole new perspective just by being able to say to somebody, hey, you need to talk to an attorney about how you're going to take ownership of this property, right?
Yeah, absolutely.
That's what I was thinking. If they didn't have an agent who told them and they didn't know to ask for survivorship or anything like that, then they're just going to be tenants in common.
That's exactly right. That's exactly
Which sucks for people like, before the same-sex marriage thing and everything. If they didn't know to do joint tenancy, they'd be tenants in common. One of them dies, it goes to whoever is in their will.
Choices are important when they
for their
put
heirs.
these properties together. It's an important choice.
Very.
Can you be tenants in common with right of survivorship?
No, tenancy in common does not. If you want the right of survivorship, you have to ask for joint tenancy.
Which is the common key differentiating factor for that one.
Right. So on the test, I love that because on the test, it makes it easier. Tenants in common, no survivorship. Joint tenancy, survivorship. It's just an automatic association.
All day.
Right. The two of them are tied. They're tied at the hip.
And if you're married, you don't have to ask what it is. You automatically, if you're
That's
married,
right. Like
you're
most things,
automatically tenants in the entirety.
that's right. Like most things with marriage, you get told what to do if you're married. It's pretty much the way it works with marriage, right? Somebody decided for you. But yes, if you're married when you purchase the property, it is automatically tenancy by the entirety. You don't have to ask. So those are the ways that people can own property together traditionally. There are also much more complex ways to share ownership of property. Now, some people might ask why we want to make this more complex, but I'll tell you why we need to make it more complex. There's a problem with joint tenancy. There's a problem with tenancy by the entirety. And it goes back to that question that was asked a couple of times about the percentages and the use. If we have 3 owners of a property and they're tenants in common, how much of the time can one of those 3 owners occupy the property?
All the time.
All the time.
All the time. How much of the property can one of those 3 owners occupy?
All of it.
All of it. So I'm just going to throw this out there as a hypothetical. Let's say you get 3 families that want to buy a beach house together because they're going to share the beach house. Does that happen from time to time, by the way? Do families go together and buy beach houses with each other? Does that happen?
Yes.
Here's the thing, though. They go in together and they all like each other and they're all going to share. If they purchase that property together as tenants in common, what can you do if one of them won't ever leave? What can you do if one of them spreads out and takes over the whole place and says, no, we're just going to live here year round? Can you do anything if you're one of those other owners?
No.
No, because since they're an owner, they have the right to be in that entire property all the time. Does that make sense for everybody?
Got it.
So there are other methods to share ownership where we can further limit what the co-owners have the right to do. There's a way that we can limit how much of the space that co-owner. Would it be good if we could take that beach house and divide it into 3 units and say to the 3 families, now you can be here all the time if you want to, but here's your unit, here's our unit, here's this unit. Would that be a better way to do it?
Yes.
Guess what we just turned that thing into, folks?
Condo.
That's a condo. That's a condo. A condo is taking a shared structure and basically putting lines on the floor and saying, this is my space, this is your space, stay the hell out. That's a condo. But ultimately, how do they own the property? As one big what?
As a whole.
One big
As a
property.
group. They own it as a group of people, right? But they have their own spaces within that structure. That's a condo. We could go one step further. What if we divided that thing into units and said, but you can only come 1 weekend a month to your unit? Guess what we would call that?
Timeshare?
We would call that a timeshare. So I want to give you some perspective on what these things are that we're about to talk about. These are just really fancy ways of taking a property and dividing it up amongst a lot of people. That's all we're doing. That's all this hybrid or community ownership does, is it divides up one piece of real estate under with a lot of people and makes it so they don't kill each other in the process, so that they have their own space, their own divisions with each other. That is the purpose of things like a condominium. So when we talk about condos, first of all, a condo can be any type of structure. It can be tall, it can be short, it can be 1 story, it can be 20 stories tall, it can be for office space, it can be for residential space. Don't get locked into a condo is one thing. A condominium unit is this. It's a piece of land with a building on it, and you're going to have multiple owners of that building and land, except they don't want to share space within the property. They want to own the property together, but they don't want to share space. They want their own space. So here's what we're going to do. We're going to let them buy the land together. We're going to let them buy the building together, but we're going to take the space, the airspace, and we're going to divide it up into units. That's a condo. So when somebody buys a condo, they are buying their share of the building and their share of the land, but they're buying that as a group with everybody else. What are they actually buying by themselves? What's the one thing that they're buying by themselves that's theirs and theirs alone about that condo?
The space.
Their unit.
Airspace of their individual unit. They share ownership of the building. They share ownership of the land. They share ownership of the parking lot. They share ownership of the swimming pool, but they individually own the airspace within their units. That's what allows them to keep other people who also are owners in that same condominium complex out of their unit, because that airspace within that unit is theirs individually. Does that make sense for everybody? Is that sinking in for you? How do we feel about that?
Good. And one thing I wanted to ask about, which it always struck my mind when we went over this. So they can buy this airspace in Severalty or Concurrent with another owner?
Sure. If you have a husband and wife who buy a condominium unit, they would be buying their unit as tenants by the entirety, their airspace, but then they would be buying into the group of other owners as tenants in common for the shared ownership of the land and the building.
Okay.
So,
but as far as our purposes in class, typically Severalty.
Yes, I mean, just to make it simple as far as talking about it goes. Yes.
Okay.
So when you look at this building, if there are 20 units in this building, if we sit here and we just draw them out, and you got unit, divided out here in this building like this. Okay. Every one of these units is its own airspace, but who owns the land?
Everyone.
Everybody
Everyone.
together. Well, and if you have a group of owners together who didn't all buy at the same time and aren't married to each other, are they tenants by the entirety, joint tenants, or tenants in common for that land?
Tenants in common.
Tenants in common.
Tenants in common for that land. Who owns the building?
Everybody.
All the owners.
Everybody together. So are they joint tenants, tenants by the entirety, or tenants in common for the building?
Tenants in common.
Tenants in common. But who owns unit number 3B right here?
One
Sally.
individual.
Sally.
One individual.
Some individual. And so Sally owns the airspace of unit 3B.
I think
Plus-
they specify from the paint in.
From paint in, that's exactly right. Paint to paint and carpet to ceiling. It's easy way to think of it. Everything outside the paint is owned by the group collectively. So and I've given you those details on this side. Each unit owner holds individual title or individual ownership of their airspace within their unit. And then everybody owns the building and the common areas together as tenants in common. Now, in North Carolina, we have a very specific law that deals with condominium sales in this state. And in North Carolina, the North Carolina Condominium Act of 1986 applies only to condos that are being sold the first time they're sold. Because look what it says right here. It only applies to them when they are what?
New.
No.
When they're new. How many times is a condo going to be sold as new?
One
One
time.
time. So this law only applies to the condo the first time it's sold. And basically, here's the big thing you need to understand. If you sign a contract that promises to buy a condo in North Carolina and it's new construction, it only applies if it's new construction, you get the right to change your mind and get all your money back for a certain period of time by law in North Carolina. What's that period of time? What does it say it is?
7 days.
7 days. So if you are buying a new construction, do you get 7 days to change your mind if you're buying a resale condo?
No.
No, only new construction. If you're buying a brand new, never before occupied condominium unit in North Carolina, you get 7 days after you sign the purchase agreement to change your mind, cancel the agreement, get all your money back. That might show up on the state specific section of the test. Are we all okay with that?
Got it. Yes.
Now, cooperatives, something I'm not going to spend much time at all on here because they simply don't exist in North Carolina. This is just going to be a vocabulary word for you. When you see a cooperative as a form of ownership on the test, look for magic words like ownership of stock, purchase of shares of stock. You don't need to understand how a cooperative works because they're not going to ask you any deeper questions than that. You just need to know that when you see them talk about changing ownership in a structure using the purchase of stock in a corporation, they are talking about a cooperative. So that's strictly a vocabulary thing right there. Townhomes are another form of shared ownership in North Carolina. There are common areas here, folks. There's the parking lot. There's probably a clubhouse. There's usually like some kind of green space. All of those common areas have to be owned as a group. And that usually those owners function as a group through something called a homeowners association. And that's going to be the same with a condo homeowners association. When you have this shared ownership, well, if everybody owns the building, then everybody has to maintain the building. The best way to do that is to form yourself into a homeowners association. And so you'll see that same sort of dynamic happen with townhomes. The big thing to understand about townhomes, which is different than condominiums. With condominiums, who owns the land that the building is built on?
Everyone.
All
the owners as a group. With townhomes, the land is individually owned. You as an individual own the land that your house is built on. The property line is actually the wall that's shared between the two houses. That's going to be the property line. Here's how you can really tell if something is a townhouse or a condo in North Carolina. If you look up the property record card with the county courthouse and it shows acreage 0, what kind of property are you dealing with? If it shows no acreage at all, what are you dealing with?
Condo.
A condo. If it shows 0.002 acres, what are you dealing with?
Townhouse.
A townhouse. Because with a townhouse, there is going to be some land involved because the actual land that the structure sits on is individually going to be owned. Okay. The last type of hybrid ownership that we get to talk about today is everybody's favorite, the timeshare. A timeshare is a shared form of ownership where we've gone one step further than even condos go. Condos take a big building and divide it up into units so that people have their own space. Let me ask you a question though. If we have a building that has 100 units in it, and we divide it into, and we handle it or manage it as condos, how many owners can we have for those 100 units?
100.
100. Because each owner has ownership of the unit all the time. If we take that same building and we manage it as a timeshare rather than condos, and we said, you know what, each of these 100 units is going to be sold by the week. Each owner is not only are they going to be limited to one unit, but they're going to be limited to 1 week per year. Wouldn't that mean each unit could have 52 owners if you were limiting each unit, each owner to only use their unit 1 week a year? Wouldn't that mean each unit could have 52 separate owners?
Yeah.
Correct.
And if you have 100 units in the building, could that same building now be owned by 5,200 separate people?
Yeah.
That is a timeshare, folks. It allows the spread of ownership among a huge number of people. Well, there's an upside to that. The upside is that the cost of ownership becomes very low because you're spreading it out among a lot of people. What's the downside to spreading ownership out among a lot of people?
Upkeeping responsibility.
It's the more people you put in the pot, doesn't it get harder and harder to deal with and harder to manage?
To manage, yeah.
You don't know who you're going to be owning this thing with. And then it becomes a question of, well, if I can only use it this 1 week, how many of you have ever had a beach house that you own the whole year and you find yourself only using it 2 or 3 weeks a year? What if you've literally only got 1 week to target? How many people do you think completely never use these things at all because they happen to be busy on their week or they don't plan? A lot of people. A lot of people. And
there's whole businesses made around getting people out of their timeshare contracts.
That's exactly right. Because once you purchase one of these things, you're stuck in it with all the maintenance expenses because they're a tremendous. And are you going to have to pay property taxes? If this is something you own, are you going to have to pay property taxes on this thing?
Yes.
And are you going to have to pay into the maintenance fund for this building since you're an owner?
Yes.
Yes. So there's a tremendous ongoing expense here. And so people find themselves very often trapped in these. Now, this is the basic definition of a timeshare. It's the guaranteed use of a unit for some period of time each year. And usually that's a week, 1 week per year. It could be 1 month per year. It could be 1 weekend. But the most common is 1 week per year. And that is spread out over a number of years, usually for an indefinite time period. In North Carolina, we define a timeshare as having to be at least 5 separate time periods. And that has to be spread out over a length of time of at least 5 years. So the time to be considered a timeshare contract in North Carolina, how much time do you have to be agreeing to? At least how many years?
5 years.
5 or more years. And how many times do you have to be agreeing that you will be able to move in and move out? How many different occupancy times at least does it have to be?
5.
5. If it meets that requirement. So let's just talk about that requirement for a second. Grant purchases the right to occupy a property every other year for the next 8 years, 1 week per year. 1 week per year, every other year for the next 8 years at Wilmington. Is that a timeshare in North Carolina?
No.
No.
Oh,
No.
There's only 4.
So every other year for 8 years, how many times will Grant move in and out of that property?
4.
4 times.
And that's not at least 5. How about if we said Grant has purchased the right to use a property in Wilmington 1 week per year, and we don't put a time limit on it? Is that a timeshare in North Carolina? If we leave it open-ended, what do y'all think?
Maybe.
Yes. If you leave it open-ended, it never ends. So that's definitely a timeshare, right? So make sure you're applying that. If it adds up to be 5 times in and out and it's spread out over the course of 5 years, then it's a timeshare in North Carolina. North Carolina is not a timeshare friendly state. Timeshare developers hate doing business in North Carolina. We are a consumer protection state when it comes to timeshares. In North Carolina, if you ever go to a timeshare presentation, now I mean you're actually in North Carolina at the presentation. I don't mean you went to Vegas and they're trying to sell you a timeshare at a property in Wilmington. I mean you're actually at a presentation in North Carolina. If you go to a presentation in North Carolina and you want to get out of the room fast, tell them you'll take the most expensive one they got. Tell them to write it up. Give them your credit card. You know why? Look at that right there. In North Carolina, if you purchase a timeshare, if you're in this state when you purchase the timeshare, you get 5 days to do what?
Back out.
Back out, change your mind, and most importantly, what?
Get your money back.
Get your money back.
Money back. So if you ever agree to go to one of those stupid things down at Wilmington or somewhere and get the free weekend, when you go to the presentation, just walk in and be like, you don't even have to sell me. I want it all. Just here is my Amex card. Just put it all on there. I want the whole thing. I just got to get back out on the beach, and then get back on the beach and enjoy yourself. And when you get home, send them a certified letter. It says, according to the North Carolina Timeshare Act, I am electing to terminate this agreement within my 5 days and I want my money back. That's the North Carolina Timeshare Act. The other thing that is very not fun for timeshare developers in North Carolina is that the North Carolina Real Estate Commission can fine a timeshare developer, which is actually really important because it's the only time the Real Estate Commission can fine anybody. They can't fine me as somebody with a real estate license. They don't have that authority. They can't fine Seth. They can't fine real estate brokers, but they can charge money to timeshare developers. And that fine is $500 per violation with no maximum number of violations. So as an example, if a timeshare developer puts an unlicensed person in a timeshare office over like Labor Day weekend, just sitting at the desk, because you got to be licensed to sell timeshares in North Carolina, they put an unlicensed person at that desk, just meeting people, and they meet with 100 people that weekend. That's 100 violations at $500 per violation. That's a $50,000 fine for the developer. So we are not a timeshare friendly state at all. You know what we are friendly about though? We are friendly about finishing unit 2.2 because that's all of it. That's it. That's a big one, huh?
Oh my gosh. Yes.
Oh yeah.
Yes, it is.